a case, in fact, Colorado seems to be at the forefront of many of these constitutional and legal cases. Back in 1988, a case called Meyer versus Grant challenged that very issue. The legislature in past years, perhaps not unlike what they did with 1326, put the restriction and actually made it a felony to pay people to collect signatures for you. That case went before the Supreme Court and
the U.S. Supreme Court.
The United States Supreme Court, and on a unanimous decision, the court came back and said that is entirely inappropriate. You can't make criminal this notion of hiring someone to collect signatures to initiate ballot measures. And so,
but a lot of people look at this and go, "That's not right. You're hiring somebody to go out and signature. If it's a good issue, people should flock to you to sign your petition."
Well, in a free country, you know, if you want to hire somebody to help you tune up your car, you go pay them and they tune up your car. You know, you don't have to do it yourself. If you need signatures to get on a ballot, you know, nobody is forcing passersby on the 16th Street Mall to sign the petition. The guy who is devoting an entire, you know, month to collecting these signatures needs to get paid to eat. I mean, you know, there's nothing wrong with paying that guy to go out and collect the signatures.
Let's get into 1326. What does 1326 do? Before that, basically, it was pretty easy. I could pay somebody, and as long as the guy who signed the petition signed it correctly, was a registered voter in this state, it was a valid signature, and the Secretary of State goes through and surveys them to make sure they're done. How he got there, as long as he wasn't paid, the guy who wrote the signature wasn't paid, it was nobody's business. Is that, do I have that right? Pretty much?
Yeah, pretty much.
And now,
what happens now?
What happens now is the legislature read the case that Ryan referred to and said, okay, we have to allow them to get paid, but we're only going to allow them to get paid for 20% of the signatures that they collect. The rest of the pay that this guy gets is going to have to be hourly. So if you are hiring somebody to go out and collect signatures for you, 20% of their income is going to come from the number of piecemeal based on the number of signatures they get. Then they're going to go get coffee and donuts for several hours because they're getting paid by the hour at that point. And, you know, they lose the incentive to go out and hustle to get some signatures.
So in other words, if I sell things, and I've got people who work for me who work strictly on commission, that is, when you sell a car, we're going to give you some money. When you sell a new life insurance policy, you're going to get paid for it. Otherwise, we're not. We're not going to take that idea and say, if you get signatures, if you're good at collecting signatures, now it's going to be hourly. I'm going to pay you by so many an hour, or I'm going to pay you $10 an hour, but I could have made $60 an hour if I'm really good at hustling signatures. Why would anybody go out and get signatures?
Well, you know, the rationale I think that the legislature approached this question with is that if you just pay on a per signature basis, that creates some incentive for fraud. That creates some incentive on the part of signature circulators to misrepresent the issues that they're presenting to the voters in terms of in trying to convince people to sign. I think that concern is overreach. I think it was this is a bill that was in search of a problem, and the reason the bill that was adopted was because the legislature wanted to impose some different.
Let me talk about that for a second. And there have been so many legal challenges to signatures, and I've been through this myself. So what opponents do to let's use my initiative since I was familiar with it, Amendment 49, which would say that my goal was to get governments from stop being the banker for special interests, that if a government employee wants to give money, it doesn't come out of his paycheck, but he has to actually write it out himself. All right, a simple proposal. But those people who don't want that, teachers unions and other groups that use the government system to suck money out of people's paychecks and deliver it, what they did is they worked with people who would come over and have hidden microphones on there and try to show that the guy who was holding the petition somehow misrepresented it, or didn't say this, or didn't say that. And then, lo and behold, when we brought in the signatures, they would say, these are fraudulent, and here's why. Well, so isn't that a good argument? Doesn't that take away the incentive? Let's say, for argument's sake, that one of these petition gatherers didn't understand what's on this petition as well as he should, or didn't say it, didn't translate what it is.
Well, I'm not convinced that how this guy is getting paid has anything to do with whether he's misrepresenting or not misrepresenting. In every petition, the subject matter is listed on the petition. There's an explanation for the signer as to what they're signing. And really, in terms of is this fraud, is this not fraud, you have to look and see, is there a compelling government interest in preventing fraudulent signatures from being collected? And I think a good argument can be made that yes, there is a compelling government interest in preventing fraud, but that is tempered by the notion that the worst thing that happens here is the voters of the state of Colorado ultimately get to decide an issue. So even if there is a bit of fraud, and I'm not convinced that this initiative, this 1326, addresses that, you know, the ultimate end game is, hey, if the voters don't want it, they're going to vote it down. If they do want it, they're going to adopt it.
So in other words, let's assume that everyone carrying a petition lies about what's on that piece of paper. It requires two things. It requires that everybody who signs, yes, please put this on the ballot, doesn't read what's right above it. And on every single signature page is the ballot language, so they can read it and say, what you just said, that's not what's here. Right. So all right, but let's assume that every single petition gatherer lies and says, if we put this on the ballot, this is to bring lollipops to poor children free of charge. And what in fact what it is to execute red-headed children. All right, so there it is. We give it, and they don't know what they're doing. We still get to vote on the petition. That's
right. I mean, the process of being able to debate through the issues, have a campaign, debate the relative merits of the initiative once it's on the ballot is not prejudiced in any way. You still have that opportunity to make your case to the voters when they're going to the polls to elect it. It's the question of what kind of a standard or what kind of restrictions do we think are appropriate to put on it to actually get over that hurdle of getting on the ballot to be able to make the case to the voters.
So the real issue becomes all these restrictions that they're now putting on, like you can only get 20% of your income through piecemeal work, the rest has to be hourly. They have provisions that require training for signature collecting. You have to agree to make yourself available at any time if you're a petition gatherer, if you're a signature gatherer, for challenges. Meaning if you're a student working here in the summertime and you're flying to Europe for fall semester and you've gathered signatures all summer long and now you're in Paris studying, if there's a challenge you have to agree to fly back from Paris and go through whatever procedures and processes exist.
Now, having been through this, pardon me for being skeptical, but I know a lot of this is merely to tie things up in court. We were tied up in court. This is what's known as nuisance lawsuits. They put in the complaints really don't cost much except to hire Mark Gruskin to go out there and do this. So he gets paid, wonderful for him, but the whole thing gets gummed up. Now it's going to be a whole lot easier for people who don't like the issue going on the ballot, instead of fighting it in front of the voters in the fall, fight it in the courtroom over all this minutia.
And not only that, John, if you are a person that is pushing an initiative and the other side wins because there is some fraud on some signatures, you have to reach into your own pocket and pay their attorney for litigating those issues.
The actual petition gatherer.
No, the gatherer is not necessarily the person responsible. It's the proponent of the measure. So if you
I contracted this out to Ryan to do the work.
It doesn't matter.
Ryan messes up, and I've got to pay his legal fees.
That's one of the fundamental, the huge changes in this law is it's shifting the burden back on, and in terms of the cost for legal fees.
You don't have to pay Ryan's legal. Well, you do have to pay Ryan's legal fees, but you have to pay the other guy who is suing you and Ryan.
So in other words, going back to the guy who tuned my engine. So I pay him to tune my engine instead of tuning it myself. He does something wrong, and I've got to pay for his attorney, and I've got to pay for the attorney that sued him, even though I didn't do it.
Right.